Hello friends, welcome back to the series of lecture. I am Advocate Gaurav Singh Adana and we are continuing with the CRPC. This is the 43rd lecture of the CRPC. In today's lecture, we are continuing with the section 436. When any person other than a person accused of non-bailable offence. Other than a person accused of a non-bailable offence means what? It means bailable offence when any person other than a person accused of a non-bailable offence is arrested or detained without warrant by an officer in charge of a police station. Arrested means arrested and detained, or detained means surrender and detained. So here arrested means arrest होने के बाद detain किया गया और detained means surrender करने के बाद detain हुआ. Arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before a court. Appear means appears on the summons, or brought before the court means he was arrested then brought before the court, or maybe he has surrendered then he would be brought before the court, and is prepared at any time while in custody of such officer or at any stage of the proceedings before such court to give bail. Such person shall be released on bail. It is a bailable offence, na? Obviously, in bailable offence, the bail will be granted provided you furnish the bail bond. It is a bailable offence, and bailable offence when you have right to obtain bail, and therefore the police officer or the judicial magistrate, अब जिसके भी पास हो, अगर पुलिस ऑफिसर के पास हो, then he would grant the bail, and if he is a judicial magistrate, then he would grant the bail. And it is the duty of the said police officer or the judicial magistrate to inform you that it is a bailable offence, and therefore you have right to obtain bail. Thereafter, the condition of the bail would be laid down, and the security and surety would be mentioned, and if furnished the bail, it shall be released on the bail. That is a matter of right. And please note it down somewhere that it is the duty of the police officer to inform you that it is a bailable offence and you are having the right to bail, provided that such officer or court, if he or it thinks fit, may and shall, if such person is indigent and is unable to furnish surety, instead of taking bail from such person, discharge him on his executing a bond without surety for his appearance as hereinafter provided. It means अगर इंडिजेंट पर्सन है तो उससे आप श्योरिटी नहीं मांगोगे, उसके पर्सनल बॉन्ड पर आप उसको रिलीज कर दोगे. You will take a personal bond. The bond will be there. You will mention it that he would appear. The bond will be there, and it will mention the conditions, etc. I will appear, all that. And after taking the bond, he would be discharged. Then he would be discharged if he is an indigent person. Read it again. Provided that such officer or court, if he or it thinks fit, he means police officer, it means court, it thinks fit, may and shall if such person is indigent. अब इसको ब्रेक करके पढ़ेंगे. may and shall बताते हैं. Provided that such officer or court, if he or it thinks fit, may, then jump, instead of taking bail from such person, discharge him on his executing a bond without surety for his appearance as herein after provided. मीन्स पुलिस ऑफिसर या कोर्ट के पास पावर है कि आपको पर से विदाउट श्योरिटी भी आपको रिलीज कर सकते हैं, लेकिन अगर आप इंडिजेंट हो देन दे आर बाउंड टू. अगर आप इंडिजेंट नहीं हो देन दे मे और मे नॉट release you on the personal bond, but if you are indigent person then they are bound to release you on personal bond. तभी यहाँ पर shall लिखा है. Now again read. Provided that such officer or court shall, इधर से jump कर गया, shall, if such person is indigent and is unable to furnish surety, instead of taking bail from such person, discharge him on his executing a bond without surety for his appearance as hereinafter provided. Means अगर what they are saying is, वैसे तो they would take bail और bail में security भी होगा और surety भी होगा, लेकिन they may, if they want, could release on personal bond. They may release you on personal bond without sureties. But if you are an indigent person, if the accused is an indigent person, then they shall release on personal bond. If the accused is an indigent person, then they shall release the accused on personal bond. That is the application of may and shall. They are having the per se discretion of releasing the accused on bail or personal bond. But if the accused is an indigent, then they are bound to release him on personal bond. Where a person is unable to give bail within a week of the date of his arrest, it shall be a sufficient ground for the officer or the court to presume that he is an indigent person for the purpose of this proviso. मीन्स अगर आप अरेस्ट के एक हफ्ते के अंदर बिल फर्निश नहीं कर पाए, दैट शुड बी सफिशिएंट ग्राउंड टू बिलीव दैट द एक्यूज्ड इज इंडिजेंट, एंड उस केस में एक्यूज्ड को पर्सनल बॉन्ड पर छोड़ दिया जाएगा. एदर द एक्यूज्ड प्रूव दैट ही इज इंडिजेंट, और एक हफ्ते तक वो कस्टडी में रहे एंड नॉट फर्निश द बिल, देन ऑल्सो ही वुड प्रिज्यूम टू बी इंडिजेंट. या तो वो खुद प्रूव कर दे, और या फिर वो एक हफ्ते तक कस्टडी में रहे और फर्निश ना करे बिल को, तो वो अपने आप प्रूफ हो जाएगा दैट ही इज इंडिजेंट. नाउ व्हाट वुड बी द बेनिफिट ऑफ बीइंग ए इंडिजेंट? दैट द एक्यूज्ड वुड बी रिलीज्ड ऑन पर्सनल बॉन्ड. एंड हु इज द इंडिजेंट पर्सन? इंडिजेंट इज ए पर्सन हु इज नॉट हैविंग द प्रॉपर्टी और मनी टू फर्निश द बेल. अब या तो एक्यूज्ड प्रूव कर दे बाय डॉक्यूमेंट, पेपर्स एंड ऑल दैट ही इज इंडिजेंट पर्सन, या फिर एक्यूज्ड एक हफ्ते तक फर्निश ना करे बिल, देन इट वुड बी प्रिज्यूम दैट ही इज इंडिजेंट, और उसको बिल पर छोड़ देंगे. लेट्स सी नेक्स्ट प्रोविजन. प्रोवाइडेड फर्दर दैट नथिंग इन दिस सेक्शन शैल बी डीम्ड टू अफेक्ट द प्रोविजंस ऑफ सबसेक्शन 3 ऑफ सेक्शन 116 और सेक्शन 446A. Now this proviso is talking about the subsection 3 of section 116 और 446A. तो ये जो प्रोविज़न है ये नहीं लगेगा किस पे? सबसेक्शन 3 ऑफ 116 या 446. They are the special provisions. Look that and read once. So this is the exception of this provision. It is necessary to mention this in the exam, because without exceptions and explanation the answer is not complete. So 116 में और 446A में there the 436 will not apply. Now look at the second clause, notwithstanding. यहाँ पर आप cancellation की बात कर रहे हैं. Notwithstanding anything contained in subsection 1 where a person has failed to comply with the conditions of the bail bond as regards the time and place of attendance, the court may refuse to release him on bail when on a subsequent occasion in the same case he appears before the court or is brought in custody, and any such refusal shall be without prejudice to the powers of the court to call upon any person bound by such bond to pay the penalty thereof under section 446. So in subsection 2 they are talking about the cancellation. So basically clause 2 is talking about, मान लीजिए इधर किसी accused को bail मिल गया and bail is having conditions पे होती है bail, security या surety दोनों. On these things the bail would be granted. So conditions are of which kind? That you would appear on dates before the court, or if whenever the police officer requires you would appear before him, plus you would not threaten the witnesses, so and so forth. So वो सारे conditions होंगे. So what they are saying, after the bail if the person violates the conditions, अब conditions कुछ भी हो सकता है, it may be appearance or it may be threatening, threatening of the witnesses, etc. If the accused violates the conditions, then what? जैसे ही accused bail conditions को violate करेगा, court would issue the arrest warrant. कोर्ट का डिस्क्रिशन है कि एक और डेट के लिए वेट कर ले, नेक्स्ट डेट लगा दे, तो एक और डेट लगा दे, नेक्स्ट डेट पर वेट करे, उस डेट पे आप एक्यूज्ड आ जाए या नहीं, या फिर पर से द कोर्ट वुड इशू एन अरेस्ट वारंट. अब जब कोर्ट ने एक्यूज्ड को अरेस्ट वारंट इशू कर दिया, या फिर अरेस्ट वारंट इशू नहीं भी किया है लेकिन एक्यूज्ड नेक्स्ट डे अपीयर हो जाता है, नेक्स्ट हियरिंग पे अपीयर हो जाता है, एंड इफ द एक्यूज्ड नॉट हैविंग सफिशिएंट कॉज, due to which he has violated the bail conditions. If the accused is not having the sufficient cause to violate the bail conditions, then what? The court will cancel the bail and take the accused into the custody. जिस दिन accused को court में appear होना था, he not appeared, so he had violated the bail conditions. Then next what? Next the court may issue arrest warrant or may not. If he does not, if the court fixed another date of hearing and on that date the court will wait for the accused to appear. If the court issues the arrest warrant, then the accused will be arrested and brought before the court on the next date of hearing. And either of these cases, in both of these cases, when the accused is brought before the court will seek an explanation from the accused that why he did not appear on the earlier date. And if the accused is having the sufficient cause, then the court will go ahead. But if the accused is not having the sufficient cause, the court will cancel the bail of the accused and take him into the custody. So this is what written in this section. अगर ध्यान दो तो it is written may here. Court may. Notwithstanding anything contained in subsection 1 where a person has failed to comply with the condition of the bail bond as regards the time and place of attendance, the court may refuse. They are not writing shall, they are writing may refuse. Means if the accused is having sufficient grounds to prove as why he could not appear earlier, तो उस केस में कोर्ट accused का bail bond cancel नहीं करेगी. It will go ahead. But if the accused is not having sufficient ground, then the court may cancel the bail bond of accused and take him into the custody. So that is about the cancellation. So ये जो bailable offence में bail मिलता है 436 में मिलता है, cancel कहाँ पर होगा? 436 clause 2 या फिर 439 clause 2. या तो 436 clause 2 में होगा या फिर 439 clause 2 में होगा. 437 में 436 वाले बेल का कैंसलेशन नहीं होगा, because 437 is regarding bail given by the magistrate in non-bailable offence. So note it down, the bail under section 436 will be cancelled in 436 clause 2 or 439 clause 2, not under 437 by court of session. Make corrections by court of session or high court under 439 clause 2 और 436 clause 2 में ही cancellation होगा and not under 437. Then there are further sayings, when on a subsequent occasion in the same case he appears before the court or is brought in custody, and any such refusal shall be without prejudice to the powers of the court to call upon any person bound by such bond to pay the penalty thereof under section 446. 446 we have to read later on what they are saying. देखो अब बेल में जब बेल मिलती है तो सिक्योरिटी होती है accused की तरफ सिक्योरिटी होगी, प्लस सिक्योरिटी भी अगर है उसका तो सिक्योरिटी की तरफ से भी सिक्योरिटी होगी. जो 446 का रेफरेंस है वो इसलिए है कि जब आपका बेल बॉन्ड फॉरफिट होता है तो सिक्योरिटी जो एक्यूज के वो तो फॉरफिट होगी. बेल बॉन्ड जब कैंसिल होता है तो जब एक्यूज का बेल कैंसिल हो गया तो सिक्योरिटी तो उसका फॉरफिट होगा, बट जो सिक्योरिटी द्वारा दी गई है, सिक्योरिटी द्वारा दी गई है उसकी तो वो भी फॉरफिट होगी. एक्यूज की सिक्योरिटी वुड बी फॉरफिटेड, द अमाउंट वुड बी टेकन फ्रॉम द accused when his bond is forfeited, but along with the accused surety also liable for the forfeiture of the security amount he has promised in the bail bond. So that is what they are referring. They had refer the 440 section 446. So accused का security तो जब्त होगा ही होगा, पर जो सिक्योरिटी है उसने जो भी अमाउंट बिल बॉन्ड पे मेंशन किया था वो भी उससे जब्त होगा. दैट इज कॉल्ड पेनल्टी. दैट अमाउंट इज कॉल्ड पेनल्टी. द अमाउंट वुड बी टेकन फ्रॉम द सिक्योरिटी एज अ पेनल्टी. द अमाउंट इज टेकन फ्रॉम द सिक्योरिटी एज अ पेनल्टी एंड फॉरफिटेड फ्रॉम हिम, एंड इफ द सिक्योरिटी इज not pay that amount, then his property would be attached and the amount would be taken. That is why they are referring the section 446. So what we had seen 436 में arrested या तो arrest करके produce किया जाता है या surrendered and then produced, that is on bailable offence. Police officer judicial magistrate, it is the duty of the police officer judicial magistrate to inform that it is a bailable offence and he can get the bail. Then we had seen the bail security and surety may release him on personal bond. अगर indigent है then shall release him on personal bond. That all the ingredients we had seen. Then clause 2 we had seen कंडीशन होती है बेल में, जब बेल ग्रांट होती है उसमें सिक्योरिटी होता है, सिक्योरिटी होती है, कंडीशंस होती हैं, अगर वो कंडीशन फुलफिल नहीं करता है तो उसको अरेस्ट कर लिया जाता है बाद में उसके, और उसका जो बॉन्ड है फॉरफिट कर दिया जाएगा. फुलफिलमेंट ऑफ कंडीशन नॉट डन, मे इशू अरेस्ट वारंट और गिव नेक्स्ट डेट फॉर ऑफ हियरिंग. ऑल दीज थिंग्स वी हैड सीन. आफ्टर दैट वी हैड सीन कि द बेल का कैंसिलेशन सेक्शन 436 विल बी कैंसल्ड अंडर 436 क्लॉज 2 और under 439 clause 2 by the High Court or Court of Session, but it would not be cancelled under section 437. Then we had seen 446 का reference क्यों दिया गया, for feature of the security of accused की and sureties की also. अगर वो नहीं देते then it would be forfeited by the property, उनकी property को attach कर लिया जाएगा. Now let's see section 436 से, where a person has during the period of investigation, inquiry or trial under this code of an offence under any law not being an offence of which the punishment of death, means death sentence वाले provisions में ये section लागू नहीं होगा. यहाँ पे भी death sentence का punishment है जिन section में, उसमें ये section लागू नहीं होगा. Again see, where a person has during the period of investigation, inquiry or trial under this code of an offence under any law, अब इधर से जंप करते हैं, undergo detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offence under that law, he shall be released by the court on his personal bond with or without sureties. So what are they saying? They are saying that suppose there is an offence, उसका maximum punishment है 10 साल, 10 years. अब मान लीजिए here the FIR is lodged, investigation start. Somewhere here the accused is arrested and it continues in custody thereafter, and 60 and 90 दिन के पहले चार्जशीट लग गया before 60 or 90 days, whatever the case may be. So default bail तो मिलेगा नहीं, so he would be continue in the judicial custody. Then the inquiry also done, trial चल रहा है after that. अब मान लो ट्रायल चल रहा है और कस्टडी में वो कंटिन्यू कर रहा है. अब मान लीजिए समवेयर हेयर इन द कोर्स ऑफ ट्रायल, जो ट्रायल चल रहा है इधर से इंक्वायरी के बाद, इन द कोर्स ऑफ ट्रायल समवेयर हेयर और इन द कोर्स ऑफ इंक्वायरी व्हाटएवर, या यहाँ पर अब 10 साल का पनिशमेंट था उस ऑफेंस का, मैक्सिमम 10 years, एंड समवेयर हेयर 5 years आर ओवर, 5 साल वो ऑलरेडी कस्टडी में इधर तक रह चुका है. So has he not remain into the custody half of the period, maximum period which is given in that offence? So there they are saying that he shall be released on bail. But अगर इसमें death sentence है किसी offence में, then this section would not apply. Suppose it is of death sentence or life imprisonment, then this section would not apply. But suppose if there is life imprisonment only or 10 years or more, 10 years और उसके बीच में, but not the death sentence, then this section would apply. Because take an example, murder का जो punishment है वो death sentence तक है, तो अब उसका death sentence का half कैसे करोगे? life imprisonment और death का half कैसे करोगे calculate? That is not possible. So death sentence अगर लिखा है, then that this section would not apply. That is what they are writing in the bracket. Where a person has during the period of investigation, inquiry or trial under this code of any offence under any law not being an offence for which the punishment of death has been specified as one of the punishment under that law, undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offence under that law, he shall be relieved by the court on his personal bond with or without sureties. There are certain offences in which the life imprisonment is there, but maximum punishment, but the death sentence is not there. Example 394, section 394 of IPC, in which the punishment is imprisonment for life or regressive imprisonment for 10 years. Now in this case, if the suppose accused is arrested here, and in the course of inquiry or trial he had undergone half of the maximum of the imprisonment of that section under section 394. अब ये सोचने की बात है कि मैक्सिमम कितना है इस सेक्शन में, मैक्सिमम में लाइफ इम्प्रिजमेंट, अब लाइफ का हाफ कितना होगा। वैसे तो जो लाइफ इम्प्रिजमेंट का मीनिंग होता है, यू वुड बी द एक्यूज्ड वुड बी इन जेल until he dies, जब तक वो मरेगा नहीं तब तक वो जेल में रहेगा। अगर कोई बोले 20 साल 14 साल, दैट इज रॉन्ग। बट लाइफ इम्प्रिजमेंट को कम्यूट आफ्टर कम्यूट द लाइफ इम्प्रिजमेंट को 14 ईयर्स हो सकता है। जब हम लाइफ इम्प्रिजमेंट को कम्यूट करते हैं देन इट कुड बी 14 ईयर्स, बट अदरवाइज इट इज ऑलवेज अंटिल डेथ। बट रिमेंबर वन थिंग, कभी भी लाइफ इम्प्रिजमेंट का अगर आपको फ्रैक्शन कैलकुलेट करना है, हाफ, 1/4 etc. For that purpose, in section 5757 of the Indian Penal Code IPC, the maximum life imprisonment period is 20 years. Fraction calculate करने के लिए section 57 of IPC में it would be 20 years, but it is only for calculating the fraction. Otherwise, it is until death. अब 20 years का half कितना होगा? 10 years. So in this case, if the accused remained in custody for 10 years, होता है ना कई बार the accused in under trial और से सालों से जेल में पड़ा हुआ है and he is not getting bail, अब 10 साल हो गए उसको accused को and the life imprisonment is the maximum sentence, in that case he has to be released on bail. Suppose the offence is punishable with 3 years, then what will be the half? It is 1.5 years. Offence is punishable with 6 months, then it is 3 months, and so forth. Read it again. Where a person has during the period of investigation, inquiry or trial under this code of an offence under any law undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offence under that law, he shall be relieved by the court on his personal bond with or without sureties, provided that the court may, after hearing the public prosecutor and for reasons to be recorded by it in writing, order the continued detention of such person for a period longer than 1/2 of the said period, or release him on bail instead of the personal bond with or without sureties. अब ये कह रहे हैं कि हाफ इम्प्रिजमेंट हो जाने के बाद भी, जो भी मैक्सिमम पीरियड है उसका हाफ इम्प्रिजमेंट हो जाने के बाद भी, if the public prosecutor puts an application and the magistrate is satisfied, then the accused would be still continued in the custody even if the half period is over. Maybe the public prosecutor proves that he may influence, the accused may influence the witnesses. The case is at a very critical stage. At the trial stage, the case is at the trial stage, and at the trial stage अभी अगर accused को release कर दोगे, then he may influence the witnesses, because at this stage the evidence are to be taken. अगर अभी इसको release कर दिया गया, then he would influence the witnesses. Therefore, he shall not be relieved. So the court may continue even after the half period. Next proviso, provided further that no such person shall in any case be detained during the period of investigation, inquiry or trial for more than the maximum period of imprisonment provided for the said offence under that law. अब मान लो मैक्सिमम पीरियड 10 साल है किसी ऑफेंस का, तो जुडिशियल मजिस्ट्रेट को 5 साल में छोड़ देना चाहिए। बट इफ द पब्लिक प्रोसिक्यूटर ने एप्लीकेशन लगाया, सेकंड प्रोवाइजो के हिसाब से यही तो है, अगर पब्लिक प्रोसिक्यूटर ने एप्लीकेशन लगाया एंड द एक्यूज्ड रिमेन्ड कंटिन्यूड इन द कस्टडी, और एक्यूज को कंटिन्यूएशन हुई कस्टडी की। लेकिन मान लो ट्रायल खत्म नहीं हुआ और 10 साल बीत गए और मैक्सिमम पनिशमेंट कितनी है, 10 ईयर फॉर दैट ऑफेंस, एंड टुडे इज द लास्ट डे ऑफ दिस 10th ईयर, एंड देन इन दैट केस यू हैव टू बी, द एक्यूज्ड हैज टू बी रिलीज्ड। बिकॉज अगर एक्यूज्ड को पनिशमेंट भी मिलेगा ना तो वो 10 साल से ज़्यादा तो मिलेगा नहीं, एंड ऑलरेडी दैट एक्यूज्ड हैज गॉन टू इम्प्रिजमेंट फॉर 10 ईयर्स, सो एक्यूज्ड 10 साल सजा भुगत चुका है, देन ही हैज टू बी रिलीज। लेकिन अगर मान लीजिए लाइफ इम्प्रिजमेंट का केस है, तब क्या होगा उस सिचुएशन में? अगर हाफ में छोड़ना था तो 10 साल में छोड़ देते, बट हाफ में नहीं छोड़ा। पब्लिक प्रोसिक्यूटर ने एप्लीकेशन लगा दी दैट ही वुड इन्फ्लुएंस द विटनेसेस और देन द कस्टडी कंटिन्यूज, कोर्ट कंटिन्यूज विद द कस्टडी ऑफ द एक्यूज्ड। नाउ 15 साल बीत गए, उसके बाद 20 साल बीत गए, विल द कोर्ट रिलीज आफ्टर 20 ईयर्स? द आंसर इज नो। द रीजन बीइंग इज दैट द फ्रैक्शन के लिए तो हमारा 20 ईयर्स काउंट करेंगे, बट द एक्चुअल पीरियड इज until death of life imprisonment. Actual period is until death. Therefore, the accused would not be released after the 20 years. Rather, the accused remain into the custody until the trial is concluded. So it could be beyond 20 years also. But it is very horrific that की ट्रायल चल रही है 10 साल से 20 साल से 30 साल हो गए और ही द एक्यूज्ड रिमेन इन जेल, और लास्टली अगर कन्विक्ट नहीं होता, एक्विटल हो जाता है उसका, देन ही हैज टू बी compensated in that case. But that is a constitutional aspect we would see in the constitution. Now let's see the explanation. In computing the period of detention under this section for granting bail, the period of detention passed due to delay in proceedings caused by the accused shall be excluded. Now what does this means? Now suppose the punishment is of 10 year. सपोज इन्हें कोई ऐसा ऑफेंस किया जिसकी पनिशमेंट 10 ईयर्स है, ये इधर ऑफेंस किया एंड समवेयर हेयर द एक्यूज्ड इज अरेस्टेड एंड हेयर समवेयर द 5 ईयर्स इज ओवर, 5 साल उसके हो जाते हैं और ट्रायल अभी कंप्लीट नहीं हुई है। नाउ इन ट्रायल कोर्ट सेवरल प्रोसीडिंग्स वर टेक प्लेस एंड समवेयर हेयर एक्यूज्ड हिमसेल्फ कॉल्ड सम डिले। For example, the accused seek adjournments. Accused ने खुद ही adjournment मांगा. The defense sought some adjournment because they are not able to furnish some documents, etc. मान लो this time period is taken for this adjournment. मान लो suppose it is 20 days. अब बताइए 20 days क्यों lost हुआ? Not because of the adjournment of the prosecution. Not because of the fault of the prosecution, but it is because due to the adjournments taken by the defense. It is the mistake of the defense. Therefore, these 20 days would be excluded in counting of the 5 years. तो ये period कहाँ तक चला जाएगा? 5 years plus 20 more days. So the half period would be completed on 5 years plus 20 days. Suppose later on यहाँ पे कहीं जाके फिर the defense seeks adjournment of 40 days, तो हाफ पीरियड कहाँ शिफ्ट हो जाएगा? 5 years plus 40 plus 20 days, because the defense or accused has delayed the proceedings by 40 plus 20 days. So the half time period is 5 years 60 days, that is 5 years 2 months. So it is simply taken into mind the proceedings delay by the accused, the time period taken by the accused or defense, and delay the proceedings, that would be not be a part of the half period. That time period would be excluded. That's all for this section.